2020. The FAQs are intended to provide additional guidance to ensure Illinois residents can comply with PICA. ISP has made every endeavor to ensure our administrative rules are within the authority set forth in the statute by the legislature. These hearings are held to gather your questions and ensure we have addressed them within the limits of our authority before we move to second notice in the Joint Committee on Administrative Rules process. The public comments we have received for the hearing today will now be read, and then we will acknowledge those individuals who submitted witness slips to speak at today's hearing. As a reminder, per the public notice, if you did not submit a witness slip in advance, you will not be permitted to speak today. However, the ISP will be accepting written comments until November 20th as part of the first notice process for its proposed rules. Please remember your remarks are limited to 3 minutes. People speaking on behalf of a group, organization, or their constituents will be permitted 9 minutes. Today's meeting is being streamed and recorded. We're muted. No, I'll move. Okay. Apparently they can't hear me on the WebEx. I apologize. We're now going to read the public comments. These comments do not reflect the views or opinions of the ISP, but rather are being read verbatim into the record as a part of this public hearing process. To the extent that questions were submitted as written comments, they will be read into the record, answered to the extent possible today, and addressed further during the first notice process where necessary.
First comment that will be read is by Glenn Sanders, Mississippi Valley Hunters and Fishermen's Association members. Specific questions that we would like answered. Does a semi-automatic shotgun, such as a Benelli Super Black Eagle that can accept a magazine extension tube, fall within the definition of an assault shotgun?
The ISP would ask you to please refer to the PICA identification guide, which is available on the ISP website. There are 3 flowcharts beginning at page 82 intended to assist law enforcement officers, firearm dealers, and the public in the identification of assault weapons as defined in the recently enacted Protect Illinois Communities Act.
In computing the magazine capacity for a semi-automatic shotgun, what length shells are the guideline? The shell lengths that are in common use and availability are 1.75 inch, 2.75 inch, 3 inch, and 3.5 inch. Which should a gun owner use to figure out his shotgun's magazine capacity?
Shotgun shells are not regulated by PICA. Please refer to the Wildlife Code for this question.
Since a magazine extension tube for a shotgun can be installed or removed from a shotgun without disassembly of the trigger mechanism, does that magazine extension tube have to be registered?
Extension tubes are neither fixed or detachable magazines and are therefore not regulated by PICA.
On behalf of the MVHFA members, we request a specific reply to these questions. The next comment that's going to be read is by Roger German. I believe the Democrats' Protecting Illinois Communities Act, which mandates already owned guns be registered with the Illinois State Police, is an unlawful ex post facto law enacted in violation of both Article 1, Section 16 of the Illinois State Constitution and Article 1, Section 10, Clause 1 of the U.S. Constitution. Because at the time a person acquired the gun, it was completely legal to possess it without a mandated registration. Then to make it unlawful, as Illinois did, and say you have to register all your lawfully owned guns of a certain type, or a felony making unlawful something which was lawful when you originally did it, is an ex post facto law. Governor Pritzker and the Democratic-controlled state legislature violated Article 1, Section 16 of the Illinois Constitution, the Bill of Rights, which states, no ex post facto law or law impairing the obligation of contracts or making irrevocable grant of special privileges or immunities shall be passed. Source, Illinois Constitution. According to Black's Law Dictionary, an ex post facto law is a law passed after the occurrence of a fact or commission of an act which retrospectively changes the legal consequences of relations of such. How much clearer can this be? The Democratic Unlawful Protecting Illinois Communities Act contains an ex post facto provision. In the U.S. Constitution, there is a clause in Article 1, Section 10, which states, "No state shall pass an ex post facto law." The law-breaking Democrats who voted to enact the gun ban law shamefully violated both the Illinois state and U.S. constitutions, the same constitutions they swore an oath to uphold. We must make the government Democrats pay by the rules laid out in the Constitution. Correction. We must make the government Democrats play by the rules laid out in the constitutions. Otherwise, we will live in a police state. Here in the state of Illinois, the Democrats in the state legislature enacted a gun ban law which bans arms. On January 10, 2023, Illinois Governor Pritzker signed a bill titled Protect Illinois Communities Act, which placed an outrageous ban on more than 170 different semi-automatic firearms and magazines of more than 10 rounds for rifles and more than 15 rounds for handguns. The wording of the recent federal judge's opinion on California's ban on 10-plus round magazines is telling. Laws are not to be enacted for the prevention of future crimes. The history and tradition of the Second Amendment clearly supports state laws against the use or misuse of firearms with unlawful intent, but not the disarmament of law-abiding citizens, the federal judge wrote. Laws are for punishment of unlawful activity. What is unlawful activity, you ask? Actions that violate the laws of liberty. Illinois state government lawyers who supported the enacted bill titled Protect Illinois Communities Act, Governor J.B. Pritzker, Illinois A.G. Raoul, Illinois Senate President Don Harmon, Illinois State Speaker of the House Chris Welch, all brag they were attorneys and know the bill titled Protect Illinois Communities Act is lawful. They are persecuting gun owners. They do so to force gun owners to spend big bucks in defense of their right to keep and bear arms. The Illinois Bill of Rights contains Section 22, which is meant to handcuff state government from tampering with our constitutionally protected right to arms. The right of the individual citizen to keep and bear arms shall not be infringed by state government. The Democrats are trying to turn our inalienable right into a privilege. I remind you of this section in the Illinois Bill of Rights. Section 1, inherent and inalienable right. All men are by nature free and independent and have certain inherent and inalienable rights, among which are life, liberty, and the pursuit of happiness. To secure these rights and the protection of property, governments are instituted among men deriving their just powers from the consent of the governed. Source, Illinois Constitution. Article 1, Section 22 of the Illinois State Constitution protects our rights from state government so we can defend self, family, community, state, and country. The next comment will be from Steve Munchunski. 1, the barrel shroud language. Is a ranch model Mini 14 and 1022 legal? 2, readily convertible magazines. The statute bans magazines that are readily convertible to high capacity. What does this mean? 3, is the 1022 okay because the handguard is part of the stock? What about something like a Kel-Tec RDB-C or a handmade handguard for a Fight Light SCR receiver? We need clarification, not just on what guns are fine, but why they're fine and others aren't.
Answers to these questions can be found on the ISP website on the Protect Illinois Communities page. Specifically, we would point you to FAQ number 8. Is a forestock considered a barrel shroud and therefore regulated by PICA? No. A shroud is not an integral component of the stock, but rather a separate piece. For example, the wooden forestock on a base model Ruger 1020 does not constitute a shroud. Please see the ISP's guide. Other examples of forestocks not constituting shrouds would be the base model M1 Carbine, M1 Garand, and Savage Model 850. Assuming they have no other features regulated by PICA and or have not been modified to include any regulated features or attachments.
4, what parts are we legally allowed to purchase in the event one of our weapons breaks or we lose a trigger spring or a pin on a grandfather gun?
Again, answers to this question can be found on the ISP website on the Protect Illinois Communities Act page. Again, we would direct you specifically to see FAQ number 41. If an Illinois resident has an AR-15 or assault weapon prior to the passage of this act, where can they legally possess the firearm? Answer, after April 10, 2023, an Illinois resident can legally possess the firearm on private property owned or immediately controlled by the person, on private property that is not open to the public with the express permission of the person who owns or immediately controls such property, while on the premises of a licensed firearm dealer or gunsmith for lawful repair, and at a licensed firing range or sport shooting competition venue, or while traveling to and from these locations.
5, what is the definition of a flash suppressor? Is a muzzle brake included in this as well? They are two items with two different functions, but there's no guarantee they know the difference. Flash suppressor to mean all muzzle devices. An example for this is an M1A. Legal if the flash suppressor is swapped out for a muzzle brake. Does the MA plastic barrel cover count as a barrel shroud? The law in the ISP examples conflicts.
Again, answers to this question can be found on the ISP's website on the Protect Illinois Communities Act page. We would direct your attention to FAQ number 9. The FAQ is a muzzle brake considered a flash suppressor and therefore regulated by PICA? The answer, while both are barrel attachments, they serve different purposes. A flash suppressor is designed to reduce muzzle flash of the firearm. On military firearms, this is to prevent distant opponents from seeing where someone may be shooting from. A muzzle brake directs the energy of the muzzle blast in the specified direction in order to reduce the felt recoil of the discharge of the firearm and to prevent the muzzle from jumping during shooting. Most muzzle brakes do nothing to reduce the flash, and the specific one produced by Springfield have been ruled by ATF to not be a flash suppressor.
6, what is the policy of the state police with regard to investigation and identification of PICA categorized firearms purchased between the April 28th injunction and ensuing stay issued on?
Again, answers to this question can be found on the ISP website on the Protect Illinois Community Act page. Specifically, see FAQ number 16. How will this law be enforced? Law enforcement agencies, including the ISP, are charged with enforcing the Protect Illinois Community Act throughout the state. ISP will continue to enforce the Firearm Owner Identification Card Act and Article 24 of the Criminal Code of 2012 by partnering with local law enforcement through our Violent Crime Intelligence Task Force. The task force is a collaborative effort to reduce and prevent illegal possession and use of firearms, firearm-related homicides, and other violent crimes.
7, what is the policy of the state police with regard to the 99.9% of owners of PICA categorized firearms who have historically been fully compliant with firearm laws that simply didn't capitulate to a registration which they are reasonably likely to be unaware of?
Again, answers to this question can be found on ISP website on the Protect Illinois Communities Act, and we would again refer you to FAQ number 16, which I just read. 8, please describe how the registration above is compliant with Title 18 U.S. Code of the Firearm Owners Protection Act of 1986. Again, answers to this question can be found on the ISP website on the Protect Illinois Communities Act page, specifically see FAQ number 33. How is the Firearm Owners Protection Act of 1986, 18 U.S.C. Section 926 relevant to the ISP rulemaking under PICA? The answer is it isn't. 18 U.S.C. Section 928 applies to the Attorney General of the United States and sets forth what rules and regulations a federal agency may create to regulate firearms. The authority for the PICA and the endorsement affidavit is based upon the statute passed by the Illinois legislature and is not a rule or regulation created by a federal agency. See National Shooting Sports Foundation Incorporated versus Jones, 405 U.S. Appellate DC 18, citing RSM Incorporated versus Buckles. Rejecting argument because Section 923G5A is a statute, not a rule or regulation.
9, what logic requires a citizen, after having completed a multi-month process of applying and receiving a FOID, who can now be instantly and digitally identified to have previously purchased firearms, open parent, 10-year FOID extension, close parent, to wait 3 days to receive any new firearm after purchase?
This question does not pertain to the provisions of PICA or the Illinois State Police rulemaking under PICA, so it will not be answered at this time.
10, please describe how the digital record of purchase is compliant with Title 18 U.S. Code and the FOPA 1986.
Again, answers to this question can be found on the ISP website on the Protect Illinois Communities Act page, specifically FAQ number 33, which I just read.
The next comment will be by Brett Ryan, or from Brett Ryan. Ladies and gentlemen, thank you for gathering here today to discuss this crucial aspect of our democracy, the Constitution of the United States, and more specifically, the vital protections enshrined within the Second Amendment. Engaging in debate over the intricacies of the Protecting Illinois Communities Act can sometimes cause us to miss the forest for the trees. The more pressing matter we need to address is that the Protecting Illinois Communities Act, in its essence, stands in contradiction to our cherished Constitution. In Illinois, our law enforcement officers take an oath to uphold and defend the Constitution. Bearing this responsibility with the utmost seriousness, the Second Amendment, a cornerstone of our liberties, grants us the right to bear arms. This right is about more than just owning firearms. It's about preserving the very essence of our democracy. The framers of the Constitution knew well that an armed citizenry is a bulwark against tyranny. The Second Amendment ensures that the power remains ultimately with the people. It serves as a symbol of our freedom, our independence, and our intrinsic right to protect ourselves, our family, and our communities. Upholding the Second Amendment isn't just an homage to our past, it's a statement about our present and our vision for the future. In a world where threats are ever present, this amendment equips law-abiding citizens with the means to protect themselves and those they hold dear, bolstering a sense of self-reliance and resilience. By honoring the Illinois State Police oath, we're not just upholding a right delineated in ink, we're upholding a legacy of freedom, responsibility, and civic duty. Our democracy's strength is anchored not just in words penned by our forefathers, but in our unwavering commitment to understanding, respecting, and preserving those words. In closing, it's essential to remember that our Constitution stands as the supreme law of the land. It serves as the bedrock upon which all our laws are built, and any legislation, no matter its intent or popular appeal, must align with its precepts. The Constitution is, and always shall be, the final authority of all laws in the United States. Thank you. Let's stand together, unwavering in our dedication to upholding the Constitution and enduring freedoms it guarantees for every citizen, as embodied in the final words of the oath of the Illinois State Police. At all times, uphold the constitutions and laws of my country.
At this time, we are going to acknowledge the people who submitted witness lists. And we would first like to invite Representative Brad Halbrook to speak.
Thank you, ladies and gentlemen, for hosting this event. My name is Brad Halbrook, State Representative in the 32nd District and County member of the Illinois Freedom Caucus. I am joined here to my left with the Chairman of the Illinois Freedom Caucus, State Representative in the 101st District, Chris Miller. I'm here today representing.
I apologize, sir. That's for the WebEx. Because it's on the WebEx. My apologies.
I'm here today representing the constituents of my district, just like when I voted no on the legislation on the House floor back in January. While there were a million reasons to vote no on this bill, certainly one of the biggest issues I and many of my colleagues had was the firearm registry requirement. I want to be clear that we know this public hearing is taking place because the governor and his radical left agenda. He and his Democrat legislators passed this bill and then laid it at your feet to have to deal with it. I support law enforcement unapologetically, and we know this is not your fault. However, there are questions that need to be answered. I understand that you may not be able to answer these questions, and not for mine and others. However, we have an expectation to get those answers in a reasonable length of time. What is the reasonable length of time that we should expect those answers, and in what manner or form will they come in?
We are in receipt of questions from JCAR, and we are also in receipt of questions coming in through our public comment portal, and we are going to endeavor to have answers to those questions before the JCAR December meeting. Hopefully that will be possible. If not, it will definitely be in January, but our goal is to answer them by December.
So just to be clear, going into the JCAR meeting in December, we will get those answers back. Email, it'll be on the website. How will we know that we'll have answers to that going into the JCAR meeting?
Well, Well, we will at least respond to the people that submitted the questions, but I believe we will likely put many of those answers on our website as well.
Okay. So here's the questions I have for you today. What happens when hundreds of thousands of gun owners are non-compliant overnight and they're just otherwise totally law-abiding citizens? What is going to be their punishment for non-compliance?
Sir, my intent is to take down your questions.
Okay, I mean, I can submit these later in writing so that we don't, I'm looking for a response.
Okay, so my initial response would be that we will turn to the bill, and I believe the bill sets forth penalties for failure to file your endorsement affidavit, and so it will be up to each individual attorney in the 102 counties to decide how they will enforce that.
Yeah, so the question remains, what are the penalties?
We'll look at it. Okay, I'll look it up.
How will this registry be used as a source to later seize firearms from individuals?
Bill is not aware of any intent.
This legislation is still under a legal challenge, as is similar legislation in other states. What happens if it's declared unconstitutional and someone has already been punished? The legislation is still under a legal challenge, as it is in other similar legislation in other states. What happens if it is declared unconstitutional and someone has already been punished?
Well, I think that will depend upon the state attorney and the courts in those counties and how they handle that. Those issues won't be up to the organization to decide.
Okay.
I apologize. I said I don't believe those things will be up for the Illinois State Police to decide. I think that will be up to the state attorneys and the courts of the various counties throughout the state of Illinois.
Also, if this is overturned, will the registry be destroyed?
I can't answer that. I don't know the answer to that. I mean, I would assume that if the law is ruled unconstitutional, we would be directed by a court on how to handle that.
Will the confiscated weapons be returned?
If the law is ruled unconstitutional and a weapon has been confiscated, I would think that the law enforcement would be required to return it by. Again, those are not things that will be decided by the state police unless we have confiscated the firearms.
So I guess that's the question when it gets back to the enforcement and things like that that's being discussed today. I appreciate the Illinois State Police hosting these hearings. I think the consensus, however, will ring louder than is possible in any hearing room. Hundreds of thousands of people will absolutely not comply. It is up to the governor and the legislature to truly decide if they're prepared to declare war on law-abiding gun owners or not. One thing will be certain, this we will defend: the right to bear arms shall not be infringed. Thank you, guys.
Sir, I wasn't trying to put you off in response to your question about the penalties. It is on FAQ number 15, and the first offense for failure to file an endorsement affidavit is a Class A misdemeanor.
FAQ
15.
And then the next step is what? Just let's go through the progression of that.
First offense is a Class A, second and subsequences are Class 3 felonies.
So again, the question is, what is the definition of first offense and subsequent offenses after that?
Okay, again, that's going to be up to the state attorney and the court. Specifically, that would mean that you have to have a conviction for the first offense before it would move on to a second offense.
Okay. Thank you, ladies and gentlemen. No further questions.
We would next like to invite Josh Wachowski on behalf of Illinois Federation for Outdoor Resources to speak.
Good morning. Thank you for having these hearings. My name is Josh Wachowski. I represent the Illinois Federation for Outdoor Resources. It is a coalition of hunting, shooting, trapping, fishing, and other outdoor-related activity organizations who unite to represent the views of sportsmen and women throughout the state of Illinois. We were represented in debate and testimony related to Public Act 102-1116. We pointed out several issues with the law in common hunting firearms. Unfortunately, our concerns were not addressed. So I am here to see if we can get some of them addressed through these rules. It became clear after release of the rules that exemptions that were promised during debate were not in the law. They're not functional. There are a host of other issues. So let's go ahead and go into it. Starting on page 4 of the emergency rules, assault weapon has a definition that includes the following language. It says, including, but not limited to, those set forth in Appendix A. If you go to Appendix A on the rules, it restates the Public Act 102-1116, the definition of assault weapons. So our question is, does the Illinois State Police intend to enforce this beyond the definition of firearms or assault weapons that are in the Public Act? Because it's saying not limited to the appendix, and the appendix just restates the act.
Give me 1 second. Okay, so the answer to that question is that PICA regulates, I'm not very good at this, am I? I apologize. PICA regulates the possession of assault weapons, among other things, and sets forth a definition that conveys which firearms are included in the act. I apologize. Where it is an assault weapon is defined in the act. For additional information, please refer to section 1.9A1 and the State Police's Guide. Appendix A is not exhaustive, but rather sets forth those assault weapons that are eligible for an endorsement affidavit process and exemption to ensure that any assault weapon as defined in PICA, which was possessed on January 10th, is incorporated into the endorsement affidavit process and exemption. The ISP mimicked the legislature's use of expansive language. So the point that I would like you to take away from this is that the Appendix A doesn't decide what is regulated by PICA. Appendix A decides what is eligible for an endorsement affidavit. PICA defines what is regulated. Appendix A defines what you can do an endorsement affidavit for.
So with that said, if something is regulated by PICA, but not eligible for an endorsement under Appendix A, are you just not able to register it and you must dispose of the firearm?
That's why we use the expansive language to ensure that anything regulated could be endorsed. We have no intention of stopping people from filing endorsement affidavits if they believe their firearm is subject to PICA.
Can you turn off whatever's can't hear that? Got an echo.
Can you mute here? Okay. By PICA is
Is it by the maximum capacity of the tube magazine? Let me explain what that means. A 12 gauge semi-automatic capacity of that fire. Shotgun is capable of more than 5 rounds, and you instantly have to require registration of them. This is why we're asking.
Okay. I will need you to submit that question to us in writing, and we will give you a thoughtful response.
I heard you state in relation to Mississippi Valley Hunter Fisher Association that a detachable magazine, that a magazine extension tube is not considered a detachable magazine. Is that correct?
Yes, that's correct.
Okay, that's good to hear. Problem is, the definition of a detachable magazine states any feeding device that may be removed from the firearm without disassembly of the action, including ammunition feeding device that may be readily removed without the with the use of bullet, cartridge, accessory, or other tool. Magazine extension tube does this. It expands the capacity of the magazine beyond the 5 rounds. It's done without a tool. It appears to, if it does not meet the definition of detachable magazine, which I'm glad to hear, does it meet the definition of an assault weapons attachment? Because it will expand the capacity of a semi-automatic shotgun beyond 5 rounds.
I think we're going to have to answer that question.
We're going to have to answer that in writing as well.
Okay. The other question is,
because every semi-automatic shotgun in existence has the ability to accept those extension tubes, which is a feeding device that adds onto it, is it possible that these semi-automatic shotguns would have to be all registered because they can be readily accepting of more than 5 rounds with these extension tubes?
It is not our understanding that an extension tube is intended to be included in the definition of a magazine.
Okay.
So it would not be our understanding that every semi-automatic shotgun is subject to the endorsement affidavit requirements.
Okay. Would the extension tube be considered an assault weapons attachment, though, because it expands the capacity of a semi-automatic shotgun beyond 5 rounds? I believe attachments defined as anything that can be attached to a weapon readily converted to a so-called assault weapon.
But it doesn't, but the definition of assault weapon attachment doesn't mention expanding it beyond the capacity to accept a certain number of rounds.
I believe from Public Act 102-1116, the definition, I may be slightly paraphrasing, is anything that can be attached to a firearm to readily convert it into an assault weapon.
Correct.
So the magazine extension tube, which is readily attached to a semi-automatic shotgun, extending the capacity beyond 5 rounds, making that firearm now a so-called assault weapon, would appear to fit that definition. This is why we're asking for clarification.
Okay. We'll take your question and we'll give you additional direction.
Okay. With regards to page 5, the endorsement affidavit, assault weapon attachment specifically, if a magazine tube extension is found to be an assault weapons attachment, those have to be registered regardless of whether or not you possess the firearm it attaches to. Is that correct?
Yes.
Okay.
The PICA says that you have to register any assault weapon attachment regardless of whether you own a firearm.
So with regards to another outdoor activity, are you familiar with airsoft?
Yes, I am.
Small plastic pellet firearms. They use the same attachment points that modern sporting rifles use. So if an individual only possesses airsoft rifles, and has a forward grip for their airsoft rifle, do they have to register that forward grip as an assault weapon attachment? Because it can be attached as a second grip onto a modern sporting rifle.
It would not be our understanding that it needs to be endorsed. However, that is an issue for all 102 counties to decide how they will enforce, and I cannot tell you how they will or won't enforce that.
Okay. All right, so then we go into having possessed such items prior to January 10th, 2023. And it says that you must have, the result of sale or transfer of background check initiated on or before January 10, 2023. There were numerous legal purchases of firearms which meet the definition of assault weapon outlined in the Public Act that occurred after January 10th due to various judicial orders. Does the state of Illinois intend to force those that purchase these firearms legally to dispose of them prior to January 1, 2024, since they will not allow them to be registered?
The Illinois State Police does not get to decide that issue. The injunctions were issued by a court of law, and only the court or the legislature can decide what will happen with respect to weapons that were purchased during that time period. I'm sorry, I'm trying to speak into the microphone. I apologize. I would like to remind you that you're at the time limit, so I need you to conclude your remarks, but I would also add that if you have questions that we're not able to get to, anything that you submit to us in writing will be reviewed and we will attempt to answer it.
So I will submit further in writing. There is one other issue that I did want to get a comment on today, and that is with regards to the exemptions. Under pages 9 and 10, it states exemptions under 1230-15B, A4 or 4A and 4B. With regards to hunting, it states that if the possession extends beyond the purpose of hunting, that they must still register the firearm. To us, this says basically unless the firearm magically appears in a field and they use it only in the field for hunting, and then it magically goes away in the field, no matter what, they're going to have to register these firearms. To us, this violates the legislative intent that was expressed during the debate, because it was said during the debate and during negotiations on this legislation that the Illinois State Police and the Illinois Department of Natural Resources were going to develop a list of firearms for sporting purposes that were supposed to be submitted. And in fact, the Public Act even has this listed under Section 4 of exemptions. We are asking that Appendix B be modified to be a specific list of firearms with sporting purposes that are not required to be registered under this act. And I will submit the rest of it in writing because there is still quite a bit to go.
And we will work with DNR on the issue that you raised.
Thank you.
Thank you. We appreciate your time. Is that better for the back? If you raise your hand, it will get my attention and I'll realize that I'm not speaking into the microphone. My apologies. Okay, our next speaker is Jacob Casey, and I apologize if I pronounced your name wrong.
Is this for the WebEx?
Yes, it is.
Okay. Everybody, my name is Jake Cavney. I'm from Carlinville. There we go. My name is Jacob Cavney. I'm from Carlinville, just south of here. And the Illinois Shooting Sports Federation has answered some of the questions with regards to shotguns that accept more than 5 rounds. The Aguila mini shells specifically, could the ISB please define readily convertible to? I'm speaking in terms of especially assault weapon magazines, AR magazines. If they're chambered in 223 or 556, they'll be 30-round magazines. But if they're chambered in 350 Bushmaster, then they're 10-round magazines. They use the same body, the same spring, the same base plate. The only difference could possibly be the follower in the magazine. And you don't even have to change the follower for 350 Bushmaster to work.
We will endeavor to answer the question about what readily convertible means.
In terms of SIG P320 magazines, the compact version of those, I believe, fits the definition, and the magazines can only hold 15 rounds. However, the same model of the pistol in the full-size version holds 17 rounds. So is there a differentiation between those two things, between those two models? The 17-round magazine can fit in the compact version of the weapon, and something unique about the P320 is the trigger mechanism is the actual considered the firearm. The actual grip can be removed at any time, and you can order grips online and switch them out for a full size at any time, and they're an unregulated part. So when it comes to P320s and trigger magazine or trigger mechanisms, does ISP have a stance on those particular things?
And if you would submit your questions in writing so that we are sure that we understand the question and provide an appropriate response, we will be happy to do that.
Are FFLs exempt from the inventory from registering weapons?
The endorsement affidavit provisions are applicable to people. So if an individual is an FFL and not a business, then they would be subject to the endorsement affidavit provisions. There is no exemption specifically for an FFL in the Act.
If FFL does business as, or their FFL is under a business, they would be exempt, is what you're saying.
The endorsement affidavit provisions state that they are for a person, not a business.
Didn't the Supreme Court justify or recognize that businesses are people?
Businesses are welcome to comply with the endorsement affidavit provisions if they would like to. There is no prohibition on a business doing it. So if a business owner would be more comfortable doing an endorsement affidavit, they are welcome to do so. Our interpretation is that the endorsement affidavit provisions were intended for people, not businesses.
Sir, you're at your 3 minutes, but if you want to conclude your remarks, you can.
The last remark I'd have to say is thanks to Bishop and Todd Vandermine for keeping Illinois gun owners semi up to date and raising valuable questions as that matters.
Thank you for your time. It would be very helpful to us if you would submit your questions to that portal in writing so that we can make sure that we answer them thoroughly. Thank you. The last witness we have for today is Mr. Gregory Magnuson. Sorry, I didn't mean to butcher your name.
Tell me how this works again. I put this, turns this on, that's on.
Yep.
And then this is.
As long as it's not muted, it's already.
It's already ready. Okay, great. Okay, thank you very much for having me here today. My name is Greg Magnuson. I was born and raised in Illinois, attending school and college in Normal. This has been my ancestral home for my entire family for generations, dating back to the 1800s. They depended on the promises of the U.S. Constitution, and they built a foundation that provided the abundance this state has benefited from for hundreds of years. I consider this state my ultimate home. I moved to California 25 years ago to pursue a career in the entertainment industry. I was successful. However, what I saw happen while I was there was nothing short of catastrophic. The Democrats who wield total control over California enacted policy after policy that destroyed the standard of living, freedoms, and individual rights of citizens. Their successive rounds of gun restrictions, registration, and bans drove many Americans out of the state. It broke my heart, but finally I decided to leave California as well because it no longer represented my values and it held no future for my family and myself. I returned home in 2021 to help my parents navigate the horrors of Alzheimer's and to get an MBA. I welcome the newfound gun freedom Illinois had in comparison to California. However, in 2023, I was blindsided by this assault weapons ban. I had no indication it was coming, and there was no time to argue against it. I talk to my representatives. I call the attorney trying to stop the bill, and everyone's disbelief that this could happen here. But it happened in California, and yes, it is happening here now. Illinois' decision to enact the same type of poorly written reactionary gun ban as California will drive any gun owner out of the state who's able to leave. Illinois is surrounded by gun-friendly states that would gladly receive patriotic taxpayers as new residents. The average annual tax paid per Illinois resident is $5,700, making the 2.4 million gun owners in the state worth approximately, at minimum, $13.8 billion in annual revenue. If just half of the residents decided to leave, the state would lose $6.9 billion every year in perpetuity. For those who cannot leave, they must decide to surrender their rights or become a felon. It's misdemeanor, class 3, class 4, up to, I believe, 10 years in prison and $25,000 to $50,000 in fines. Okay, so just to clarify that. Where is the benefit? This law ignores daily gun violence that can be located easily on a map. To pander to people convinced by TV and Democrat leaders that every gun owner in America is a terrorist. I'd like to stay, but I really think my pleas here will be not even considered, and I have little faith that the court will stop this bill's implementation. And perhaps this is inconsequential to you here, but this is for the Democrats not here. I didn't know what to expect. This is my first time I've ever done this, okay? I thought maybe a representative would be here, except for this Freedom Caucus guy who actually wants to stand up for the state. This state has unfunded pension liabilities of $211 billion, massive annual budget deficits, despite the $500 million that they got as a windfall this year. Lost revenue, $2.9 billion annually from the canceled gun industry, empty office buildings in Chicago, tens of thousands of residents already escaping the state's oppressive taxes and horrible weather. It would behoove this group to reconsider implementation of this law. I urge you to veto this bill, stop all plans to enforce it before the financial loss incurred by the state is unrecoverable. Thank you.
Concludes the witness list
that we received with requests to speak at today's hearing. If you have comments, we would like to remind you that you should submit them to the Illinois State Police through its public comment portal. You can find that on our website so that we can consider your questions and attempt to address them in our public rules. We are committed to hearing your concerns and doing what we can to address them within the authority that we've been granted. If you are making reference to debate, when the law was passed, it is helpful if you know where that's found within the debate, if you point us to that so that it's easier to find. Obviously, you don't have to do that, but any information that you can provide to help us understand your question and your position is greatly appreciated. Again, we appreciate you coming today, and we will work very hard to address your concerns to the extent that we are able to do so. Thank you very much. Can you work on that? We're not going to take comments and ask him. The gentleman in the green who bent over, he had his hand up. He's walking toward the front.